we see three types of strategies implied in what judges tell that they want to be, and courts tell what they want to do. And we also see that the implications of these strategies are not very well thought out. So that's what we would like to do today. But maybe a good question first is, are these really is there a fourth or a fifth possible strategy for courts?
Well, what is, I mean, is the last resort? I mean, is this saying that courts see themselves as the last resort? Is that their strategy, or is that just a view of what we do? That's what
No, it's their strategy. As some courts say, we are not here to solve people's problems. We are not here to solve every legal issue. People have to solve that themselves. And only if all these alternative dispute resolution stuff fails, then we will come in.
Yeah, okay.
So it's,
I've heard judges say that.
Yeah.
And there's some truth in it. They're the center of the system, but they're not the entire system.
Yeah.
Okay, now problem solving. So they do see themselves as solving stuff, and it's not necessarily just legal problems? Is that, you want to explain that one?
Yeah, you see many courts in the US moving very close to people with drug problems, family law issues, and really trying to be of assistance to solve that problem, being some kind of a supervisor of processes, but being available for people, not 24 hours a day, but close to that. Calling people in to discuss options, facilitating settlements, etc.
Although you could have those too, because if you say that's the U.S. approach, it's only the U.S. approach in certain kinds of courts, drug courts and family courts.
Sure, yeah.
Last resort, a lot of courts are there, and I mean, there are U.S. courts that do that as well. And the idea is the judge says, you're going to settle, aren't you? And tosses them out. So I mean, there are two. They can be simultaneous in the same country, in the same judiciary.
Sure. There's not.
Yeah,
there,
okay.
We are looking at it from the perspective that these strategies may be conflicting. You need different resources. You need different procedures. You need different.
But they could coexist as well. And I think if you think that's the U.S. approach, this is also the U.S. approach. And as you explain it, I see where they coexist.
You see them in every country.
Yeah.
But this will probably.
But the problem solvers don't necessarily say debt collection has to be a problem-solving one. But family courts should be, and they should be holistic, and drug courts should be. Now, what's the third one?
That's, I'm here to answer your legal question. I'm a help desk for legal questions. That's kind of an approach that you also hear.
And court and ex mediation, that's what you put there, on 3.
Yeah.
If you do it like that, it will be,
as we did in Holland, as we do, I think, as we do in Holland.
Yeah, if you do it that way, you need to refer users elsewhere for the rest of their problem. That's the only thing.
Well, I mean, this is the traditional, the mouth of the law kind of approach, right? If it is a legal dispute, I will resolve it with the law. Is that what this one is?
Yeah.
So it's really the traditional approach to it, I suppose. Yeah. Okay.
But these are 3 possible strategies for imagine that you are the president of a court or the president of the council of the judiciary. These are 3 strategic options you have.
Yeah, and I see a fourth.
What's a fourth?
The fourth for me is the combination of 2 and 3 into a fourth. But that is maybe as I have understood from what I think my imagine is by these 3 is that when I start to work at the Ministry of Justice, we were in the division of the strategy of the first, the rechtspraak is ultimum Romanian, and then we got all the news about alternative dispute resolution from the US, and we want to introduce that in Holland, and we did it like in a way of 3. both, well, as I have understood, three, that the judges stays ultimum remedium,
Yeah.
last resort, but he acknowledged that sometimes there are disputes that he better can refer elsewhere, but he stays himself, the last resort approach. Some
Okay, but
judges.
then this is the strategy. If you have this, there will be many more other mechanisms needed
Yeah.
to work on conflicts, because
Yeah,
courts
that's
will only
really-
see
yeah.
5% of the cases.
Yeah, the first is what we did 15 years ago.
Yeah,
No.
but let's
Yeah.
move away from the
Okay.
typical Dutch
But you
case.
moved in.
Okay.
Yeah,
It's
but
just
you
three
moved into the
strategies
second
that you
one.
can do as
Yeah.
a court.
Well, let me
Yeah,
go
but
back.
now
Yeah.
the reason why I ask is that I think that that we now are longing to two. Well, that's the best thing if judges are solving problems, and that's how we had a good experience with mediation. But we don't need mediation. We do have the appointments ourselves, and then we have our dream. And I think, well, that's I don't believe in that dream, because I think it's a few years that goes well, but because we have now a judicial reference, so they're solving problems with judges who are trained in the law, and I would think there will be a good thing if 2 and 3 will have a synergy to a fourth.
Okay.
That you have
Well,
to go to the courthouse with both
Okay,
combinations.
then let's look at the synergy between two of these strategies after we
Yeah,
discuss
okay.
them
Well,
each.
well,
Yeah.
but I have heard Dutch judges argue one way and the other. One of them
Sure.
says this one,
Mm.
the first one.
Yeah, we have all
And-
three
but-
of judges.
But a modern one, but saying, I will encourage them to mediate, I will encourage them to do something else.
Himself, yes.
And then if they can't resolve their problems, then they come back to me and I resolve using 3, which is law.
Mm.
But, so it really is, it's a way of, it's kind of triage, that,
Triage, yes.
Triage,
Yes,
yeah.
yes, yes.
Yeah.
Diagnose and triage.
yeah,
But sorry, start
yeah.
again. We have three
Yeah, there-
three strategies. Yeah, well,
There
we
are
are
three
the,
strategies.
every week.
There's still, after this discussion, there are still 3 strategies.
Yeah.
Yes.
Yeah.
But
Yeah.
they could be combined.
They
Yeah,
could be
sorry,
combined.
they're not-
We
Of
do that
course,
at the
of
end.
course, you will not choose. I will not force you to choose.
No.
Okay.
I want you to think about taking it to the extreme. And if you would be a court president and you have this strategy, I want to be there if everything else fails. But then I want to be very effective. And I want to be highly regarded as a last resort. What would the implications be for you? How would you organize your stuff, your procedures? What kind of people would you select?
Okay, we'll do that in a minute, but let me just make one other comment to throw a wrench into the works. A court president cannot decide this, a judiciary cannot decide this. This is a decision that needs to be made in the political arena and by society. A court can't suddenly decide, I'm going to be problem solving, because,
We've got a very good example of this.
Yeah.
The best example in the world, the ICC. It is deliberately created as a court of last resort.
Yeah, yeah,
That's what it's there for.
okay. And if they
So
decided.
let's think along those lines.
Yeah, and if they
Okay.
decided tomorrow they
Yeah.
wanted to be a problem solver, they
Imagine
would.
you are
You're the president of the ICC.
you're the president,
Yeah.
And you need to make that work.
and the legal system says you should be a
Okay,
court of last resort.
all right,
How would you do it?
okay,
Have a very good selection
Yeah.
procedure.
yeah.
Last resort on what? How you select the after the selection.
Well, you also have a very good referral system, because the idea is not that you just decide at the beginning, these are the cases I will resolve. And-
Yeah. It's,
I mean,
it's
you've
part
got,
of the same thing.
yeah, you've got to, as you say down there, the other mechanisms, you've got to have, yeah.
It's interesting, huh? Courts of last resort talk about the selection mechanism, and it should be a referral
Yeah.
mechanism, in
Yeah.
the sense that the cases you don't take, where do they go? Yeah.
And most courts cannot refuse to take a case if there's nowhere else to send it, unless you've got some kind of rules that say these kind of cases will not be really.
Okay, let me just ask you, what
Yeah.
exactly do we see as the difference between the selection and the referral procedure? To make sure we.
Oh, yeah.
Well, it,
Yeah.
it,
The
it,
same song sheet.
it could be, it could go one of two ways. I mean, the way Dory describes it to me, I encourage them to mediate, I encourage them to do other things. They should go out and try it, and when that doesn't work, it comes back to me. So it's self-selection. You can have a kind of, judges can insist, but the law will have to allow them to do this, that people mediate first, and that people go somewhere else first. The other selection system is to simply be very firm about what you admit.
Yeah.
And that's what the
But
ICC does too. There are cases it won't take because it's not within
Yeah, but with referral, you mean referral to others.
referral.
Do,
to
yeah,
others.
or do you need mandatory mediation before, in the shadow of the law?
Cases with the administration will only be resolved once you've exhausted all the administrative appeals. I mean, it's such rules like that.
outside the
But
court.
the US
Judges-
Supreme Court doesn't have a selection procedure, but not a referral procedure.
Well, it has a selection procedure because it has certiorari,
Yeah.
but I don't think that worked for a trial court.
No,
Yeah,
but it's
yeah.
an example of a court that, in
Well,
which you don't have referral, but.
So does the Swedish Supreme Court, which now has a law which
Yeah.
allows it
Yeah.
to select only on the basis of sort of legal merit.
Yeah.
And if I may answer this as a success, dus that it
Yeah.
must be a success as a last resort. That's your question.
Yeah.
When will this be a success?
A great success.
And I think that it can be a success if the president, all the judges, or all the people who works at that resort have a good view over what's happening outside the court, what the kinds
Yeah.
of
Exactly. You need a
alternative.
creative system around the court.
Yeah.
Yeah.
So then
So they
you
can
need to
refer to it, not refer in referral, but they can.
You need,
Meer-
you
meer-
need a supervisor.
Yeah,
that's
supervise.
what
Yeah, indeed. Yeah, that's what I mean.
And they also need to be able to dialogue with particularly the
Yeah.
administration,
Yeah.
which may be creating problems. I mean, I saw this in Romania.
Yeah.
The Romanian administrative services were not providing services, and they didn't allow any questioning of their decisions. Everything went to the courts, and you end up filling the courts
Yeah.
with stuff that shouldn't go there. So, and there you may be the politicians helping.
I have another a point.
Yeah.
My feeling is that these courts tend to hate themselves, in the sense that
The last
they-
resort ones? Why?
in the sense that they tend to tell people, you should never come to me.
Oh yeah, no.
I'm not there for you. It's a court procedure. They tell their clients, court procedure is a disaster. You should avoid it at all costs.
Well,
It's
yeah, I mean, this
terrible.
is
They would
Hazel's
never go
End's
to court
complaint,
themselves.
yeah.
They would never recommend
Yeah.
people.
Yeah, and a lot of lawyers as well.
Yeah.
It's lengthy,
Is that what's
it's
wrong?
expensive, yeah.
I guess it depends, this depends very much on your reference. I mean, in a negative sense.
Yeah,
Yes,
and I
but
seek
it-
the
it-
positive
I-
one.
in the ICC.
I just hear.
We never
these
felt
judges-
like that at
Yeah.
the ICC.
Yeah.
No?
No, we felt we are there to make sure that the absolute bad stuff is stopped, and for the rest,
Yeah.
we work with the others to make sure
Yeah.
they do their job.
Yeah.
And that we're proud to do that.
Yeah, because you mean something for the shadow of the law.
Okay,
Yeah.
so, yeah.
But it could mean what you say,
Yeah.
if you have
Yeah.
a dysfunctional system, then it could
Yeah.
certainly mean that.
Yes, but we're trying to look when it can work. Yeah.
But if we look at what it can work,
Courts do not start to hate themselves.
Yeah.
What kind of people do they need?
With no fear.
people that can
With,
think ahead.
brave,
very
brave
strate-
people.
Very
Brave people?
Yeah,
strategic thinkers.
who are proud
Very
in themselves.
analytical, strategic thinkers. Who can think way ahead and look through lots of little problems and see the red line. The
Well,
gray lines.
to give another example,
Threads.
like yours, in Costa Rica, they didn't tell you this, but the courts had something like 2,000 cases per judge a year, and the reason was that half of their civil case law was traffic cases, which by law had to go to the court, which even even the people who were the clients didn't like, because they had to hire a lawyer and hop into court when they'd much rather pay their fine. So the courts talked to the legislature, and it took a lot of arm twisting, and removed the compulsory aspect. I don't think they feel bad about themselves at all about that.
Okay.
And people who want to go to court to contest their traffic ticket can, but the caseload dropped by 50%. Okay, budgets.
Budgets.
That's a big thing. This would probably reduce the court budget, but it would require the money be spent on those other services, because otherwise you've got nowhere else to send things. So I don't know, the state ends up paying for stuff one way or the other. It just goes into different pots.
Yeah, I think that's a very strong point.
Yeah.
And I think that many ministries of justice don't understand that.
Yeah.
That if they, and this may be interesting from a budgetary perspective,
Yes, that's
but
only-
you will have
yeah.
to spend it on other stuff.
Yeah.
So it's yeah.
No, and what, of course, ministries of justice do, they don't say we want to create a court of last resort, they say we want to cut costs.
Mhm.
And then they do
Well,
something.
yeah, but they always say by being a last resort.
Yeah, but
But
it's
it's
not
not
what they
in,
mean.
no.
It's not what they mean.
Well, I come from a legal tradition where that's regarded as perfectly acceptable, and I think I regard it as perfectly acceptable, so long as you've got other services. I do not think the courts in Brazil should be recalculating pension payments. I think someone should sit on top of the director of the pension service and say, if these mistakes keep being made, you will go to jail. And that's illegal.
More jail.
Yeah, no, but I mean, there are many Latin American countries where the pension service
I think we
purposefully
need to have a
makes
capacity here
mistakes.
to
Yeah.
write decisions, which
Yeah.
the youth law tribunal is very
Yeah.
bad at.
Okay,
Write decisions that are actionable, so that give direction,
yeah,
that provide a guidance for all the
Yeah.
other actors to then start doing stuff
Yeah.
themselves.
okay, you're not talking
So-
about judgments then, you're talking about,
Well,
Well,
not
policy.
important, but, no.
Also,
But
so they,
don't write decisions of 300 pages with
No.
500 legal theories that nobody can work
well,
with.
you shouldn't do that in any
No.
of these, I think.
That's true.
but they
What
also need
happens
to be specialists.
fairness and access to justice, and this
Well,
It doesn't change.
yeah, it doesn't change, right,
It's just done at another level.
Yeah.
It doesn't change.
it is fair.
There's complete access, except the last resort is that, and there's a lot of other stuff
Yeah.
underneath that works well, that gives
Yeah.
you, in a good system.
My hunch would be that in practice, whether you get access to justice will very much depend on how much stamina you have or how much credible threat you have to go until the last.
Yeah, but you don't have to go to the last resort. The point of this system is that there will be, it's multi-door, that there will be other places to go.
And that's our court.
Yeah, yeah, that you're not, that everything is not done by the judges and
Okay,
that
but
they- that
okay,
makes
but
it,
that
yeah.
depends on
Yeah.
whether this is happening.
That's the
Yeah.
critical one.
Yeah,
That's the critical one. If there aren't
If
alternative
that doesn't
justices.
happen,
Yeah.
it will be grossly unfair. It
Yeah.
will be only for the rich.
Yeah.
Well, if that doesn't happen, basically, last resort is not gonna work.
Then you don't have a
okay,
last
you
resort.
need different measurement,
Yeah.
yeah.
Yeah. I
Okay,
mean,
They need measurement,
yeah.
yeah. Okay,
Yeah.
shall we go to the problem solving one?
Yeah, no,
Because we are
I-
approaching where I can write.
I've won, that's a specialist, authority and special rules, special judges, specialists.
Specialist?
Yeah. To write actionable
Oh, okay,
decisions,
yeah,
you need specialized.
you need specialist here.
Yeah, but actionable decisions, I don't think, that's not what you're talking about.
No?
You're talking
No.
about judgments?
It's
Generally
a good question.
specialist,
I
yeah,
did,
or both.
I did a lot of research into this when we were setting up the ICC, and we visited a lot of Supreme Courts, and they actually all felt in their role as last resort, they needed generalists. They
Okay.
absolutely should
Yeah.
not have specialists.
No.
And I don't know what's best.
Yeah.
I just say that
Yeah.
they look for people
Yeah.
who are able to think at
yeah.
a legal abstraction level and really take the whole system.
Specialist in being
But
judge,
it's-
not specialist in the law.
Yeah,
Okay,
yeah.
yeah. Okay, yeah, I will
Yeah.
leave it immediately,
Yeah,
yeah.
Well, because a lot of the administrative decisions, for example, ought to be resolved by the
Yeah.
pension authority or
It's not
wherever
an
else.
expert.
So they don't
No.
have to have that kind of thing.
Okay, any other political implications?
Well, I'd say for all three of the strategies that put it in there, the courts needed an ability to analyze what's going on, so they could tell whether their strategy is working or not. But that's what I want to call it. And that will also back them up when they need to go to the legislature and say, hey, you want us to be a court of last resort, but you haven't empowered or forced the other agencies to provide the other services.
Yeah.
Do you have next to the ICC another example from national court that works in one country as a good last resort? Do we have an example? Does
Well,
it
I think
exist?
the one court we studied a little bit of Supreme Court of Canada, but they are last resort, and they
Yeah.
most Supreme Courts would.
Yeah, I think that the normal civil procedure, the unspecialized civil procedure is very much working like this. It's not affordable for a normal person.
Mm.
It will generally have other mechanisms before it. And yeah, only if all other things fail, you will go to it. Fabrizio?
No, can I just ask you, the definition of last resort is?
Yeah.
The idea that a court is there when all else fails.
Alternative mechanisms for resolving
Settlements.
disputes, which could be settlements, which could be ADR, which could be
Committees.
administrative tribunals. England uses a lot of administrative
Can I
tribunals.
just give you an example, because I wasn't sure whether it would fit or not. But
Yeah.
that's a typical dimension where you use private justice and you use the system of courts as a last resort. So for example, in Italy, dispute resolutions among professionals,
Yeah.
they're generally dealt by dispute mechanisms
Yeah.
within the profession. But the Supreme Court operates as a last resort if there are disputes that have to be appealed and there are due process issues that could not be solved. Would that fit with your definition of a last resort? Because this is the idea of having, because one of the issues that I was thinking about is the extent to which in alternative mechanisms you have same due process level or you don't. And you want to make sure that that's a one-point check by somebody. So that's one meaning of the last resort, which I don't know whether it fits with your definition of last resort. But if it does, I think you were looking for an example that would be an example. I don't know how much diffuse is that example, but there are a lot of private mechanisms that use
Yeah.
the public
Yeah.
as a last resort.
Yeah.
Yeah.
There will be a lot of,
Yeah,
there will
we
be
are
a lot
satisfied
of due
by.
process issues in that court.
Yeah.
Because that will be basically what you will be looking at, is as the other mechanism before it worked in a way that gives people procedural justice. Yeah.
Now, last resort also can have, I think the English system is not unlike that. You've
Yeah.
got justices of the peace who are doing little things. You've got lots of administrative boards, so there are other ways of resolving things. But you've also got online justice for simple disputes like debt collection. And so the civil procedure is used for complex cases, and the criminal procedure, if it goes to
Yeah.
more expensive courts, is used for that. So, what it is that the courts with real judges in England are last resort. The 30,000 justices
It's
of the
only-
peace are not.
Yeah.
Yeah.
And
Yeah.
a lot of
They are
people
expensive.
But
Yeah.
there's mixed.
The real judges are expensive,
Yeah.
and they're worried about that.
Yeah.
Because that didn't get resolved with the rules
That's
of
not,
courts.
yeah.
Yeah.
Just as we're worried about it in the States.
Shall we move to the next
Yeah.
strategy?
Okay.
And see, look at the implications,
Okay.
and you can come back, no problem. Solving
Okay.
problems. So this is court, it could be a tribunal, it could be a committee, but there is adjudication in it, and it's really trying to come close to the problem of the people. You could see it in some family courts, you could see it in administrative tribunals for social security. You could see it in at least in Holland, in labor courts. you could see it in in courts who use judicial facilitators. There's different ways to
Okay, but
organize it.
there are different levels
So
here.
what's the
yeah.
implications?
Well, there are different levels here at first, and by problem solving, do you mean an emphasis on mediation primarily, or an emphasis on services aside from adjudication and mediation?
What I mean is a service, whatever it is called and whatever it is, that aims at the problem as it is perceived by the people.
Yeah.
So if I have a debt problem, we will talk about all aspects of my debt problem,
Okay.
whether it's a legally sound civil obligation to pay that
Yeah.
money
Yeah.
in that moment or not. I'm in,
So it
I'm
should
in
be
trouble.
open, it should not select, it should not be about selection, it should be perceived
Yeah.
as being open to receive anything, it should have a wide ability to then
Yeah.
interpret, direct, and give the question or the issue a place.
And it will be
Something
very
which-
expensive,
Which is
and it
not
will may be
dependent on
time
the way
consuming.
why?
Yeah.
Why?
Yeah.
Well, I'll tell you, the Brazilian small claims courts that work that way now have a backlog of a year. They do a lot of mediation, they do a single hearing, but they're very popular, you don't need a lawyer. You get one hearing and things, they have an enforcement problem. But the problem is that you need many more judges.
Okay.
Okay, that's,
You
Okay.
need many more judges and you need many more
Many
services.
adjudicators.
Many
Yeah.
adjudicators, many service deliverers, unless you're gonna use a referral system.
dus in a Dutch perspective, we need a lot of burenrechters.
What
Yeah.
are those?
Yeah.
What do you mean with interest-based?
Interest-based.
Neighbor-
Yeah,
Neighbor-
neighbor
neighbor
judges.
judges.
I'm talking
Yeah.
about the wishes, the problems of the people. So you have to investigate what is what are the interests of both
Okay.
parties.
Listening, yeah.
Well, I mean, would you use a lot of lay GPs, JPs, like they have in Spain and Portugal and Italy? I don't think they work very well there, but I mean, the idea is that.
I
yeah.
probably would if I would.
Yeah. Because if you're gonna use judges for all of
volunteers.
this, it's gonna get very expensive.
Yeah.
Yeah.
Well, let's look at how the ideal one
Yeah.
would work. So I think the ideal one would also have a really good court of last resort somewhere that sets
Yeah.
some
Yeah.
basic standards that allow you to
Yeah.
do this.
Yeah,
So that every,
Yeah, I wouldn't need that. I would say, Raad, please, I will do this. I can have a family court without standard setting by the guys up in The Hague.
Yes?
you're gonna need some, because at some point, when they don't come to a decision and when they are
Yeah.
at each other's throats, someone's gonna have to decide.
And do you
Yeah.
have enough
The hard
I will
court
agree
judges?
with, I will
Yeah.
agree with my,
Yeah.
I'm the president of the court and I will tell
Yeah.
my judges to make.
Every effort to come to a reasonable solution among
make-
the parties, but, yeah, oh, okay, no?
Yeah.
Okay.
No?
To make a schedule on child support. I will tell them if they quarrel about how much compensation there would be for financial services fraud, then I would bring them together and say, okay, let's come to a schedule. And it may be formally going to the Hoge Raad, but I would.
It ought to, they can't make laws.
They do. All these courts do, so.
Well, but not to that extent, and if you're gonna publish a formal schedule, you gotta publish it, and people have gotta be able to protest it. Judges can't just decide.
That's not the,
Yeah, I
that's
mean,
not
it's-
the issue, but you will make it as
Yeah,
a local court.
okay.
You're not depending on the higher court to send you the schedules. You will make them themselves and see whether they.
Yeah, but then
I
at
think
one
there's
point
a
you
slight
have-
democratic deficit there.
Then at one point you have an argument
All
about
these
the
courts
schedule.
do it, so.
Yeah,
But then you have 3 courts setting schedules.
yeah.
And then
Then we
the.
divorce shop.
Different types, yeah.
If I'm gonna get a
No,
divorce, I'm gonna go
that's-
to Judge
Okay,
X.
this is where we differ.
I think we have
I just
to
wanted some.
ask more
what happens-
questions about this.
What happens in reality is then
Yeah.
that the court, the Supreme Court says, okay, you get it wrong in paragraph 22 of your schedule, and then they fix it, and then it's okay. So that would happen.
Yeah.
And when it gets appealed,
Not allowed.
And you need,
not allowed?
No.
They will, in an
These are
appeal, they
problem
will
solving.
not,
This is like under the tree. The
they
judge
will
under
not
the tree.
strike down the whole schedule. They will
you
just
need
say,
solving courts in the appeal from the same.
Yeah, I mean, what if the 15 judicial districts and everyone has a different schedule?
The world, the world has many different districts.
The European Court of Human Rights would not like that. That would be the ununified interpretation of the law. I don't think you can, you know. And besides, it's got to be, I mean, the public has got to be able to weigh in on
Yeah,
this.
but we are thinking about the successful solving problems courts, not the negative one.
Okay,
And how,
All right.
how you would do it, I would do it. If I would have to solve hundreds of family law cases, I would very quickly come up with these schedules, because if all my lawyers and all my judges tend to disagree on that,
Okay.
it will cost a lot of time, and there will be budgetary pressure. So I have to make schedules, I have to make rules, I cannot wait for,
do you think that most parliaments would allow courts to do that?
parliaments.
Well, parliaments, assemblies, legislatures.
You mean these?
This is a democracy we're living in, it's not a judge basis.
You mean these guys who sit there and Twitter all the time about 1,000 different topics?
Yeah, but usually insist that they retain the legislative prerogative, as
Yeah.
it's called.
What? No, I'm just joking.
Yeah, yeah,
There's a serious problem there.
Yeah.
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 So, there may be clashes with parliaments.
Legitimacy is
Yeah,
is-
that's,
Legitimacy,
yeah.
yeah.
I think legitimacy
Yeah.
can be an issue.
Formal
And with the
legitimacy
public.
is a problem, but
And with the public.
Yeah, and we have different public who loves this and public who hates this.
Yeah.
I think.
If I want Big Daddy Judge to decide me how to
Yeah.
do things, that's fine,
Yeah.
but I may prefer to have something that is
Yeah.
based in the law and not in what a judge believes is right for the
Yeah.
situation.
okay. So there may be objections from
From the public, from civil
the
rights
public or
groups,
from the users of the court.
from the users,
Which
from the
user,
public,
which users will we have a problem
the
with
one
this?
who got less than he thought he ought to get. The judges are setting up schedules.
Yeah. But we are thinking about the successful solving problems courts, and then all the decisions will be accepted by both parties.
Okay, so what it is the judge is gonna mediate and have everyone come to a.
Yeah, win-win. There is always a win-win situation.
Yeah, yeah, but it doesn't always work.
So
That's
we'll-
why- that's
we'll
where-
focus on acceptance. Yeah.
Yeah.
That's where even judges who like problem solving also realize that at some point they become last resort, because the parties are simply
Yeah.
going to be too knuckleheaded to
Yeah.
decide. Yeah.
Okay, so this will be a costly model, so it's likely that users will have to pay something or some sugar daddy.
Mm.
Let the government take it out of taxes.
Yeah. Sugar daddy,
Yeah.
such as government.
But it's expensive, but it's a very maatschappelijk effect.
Societal effect, yeah.
If a lot of problems will be solved with this by this court, and I think that it costs a lot of money, but I think I dream to live in a country where the society solves its problems this way.
Well, so do we
Or not.
all, but the judicial budget is usually 2 to 3% of the total government budget.
2 to 3%?
2 to 3%. Yes, look at Cepage. Yeah.
What I found 0.15
No, that, you're
of
looking at
the
GDP.
GDP.
You're
Okay,
looking
yeah,
at GDP.
yeah, okay.
In England, because they have because they pay very few judges, although they pay very well, most of the money, and it's 3%, goes to legal aid. That may change.
What about,
Let's
No,
first
yeah.
also ask the younger people, what indications do you
Yeah.
think
Yeah.
if courts will be more problem solving? What
I wanted
What
to
do I
know
have to-
which skills did you think of? Skills needed to
Yeah.
let people grow towards decisions.
Yeah, skills like listening,
Oh yeah.
Yeah.
like asking questions.
hey, we could make this really cheaper by getting rid of the lawyers, because if the judges are doing all the mediation, you won't need lawyers.
Although you wouldn't have anybody to ensure their interests are being served, other than
The
just
judge.
themselves.
The judge who's gonna make all the rules and make the decision and mediate. Why would you need lawyers? They just make trouble.
It says
Touche.
cooperative
It's
lawyers.
interesting, maybe I told the story already, but
Yeah.
we designed here this new procedure for neighbor conflicts. We sat here for 2 weeks with judges designing the procedure, and at no time the judges told us they needed the lawyers. So this procedure has no place for lawyers. And last week, the judges sent out a press release on it, and it was taken up by all the big Dutch media, and nobody said, where are the lawyers?
Except the lawyers.
Even the lawyers didn't say, where are the lawyers?
Well, maybe.
I think they already have given up on.
Well, maybe they figured
Yeah.
that these will be small cases where they
Yeah,
wouldn't
they have
be
to do
make any
pro
money
deo.
later.
Yeah, otherwise,
They're
yeah.
not thinking it's a big, Microsoft
No.
case, where you probably wouldn't do this anyway. But it's neighborhood disputes about whose dog was digging up the flowers in whose yard, so they're not interested in that. On the other hand,
I'm feeling that you have some.
On the other hand, there are some
Yeah,
big
but
divorce cases where.
But
they
let's,
might
but
not-
let's, let's.
But
move.
I mean, really, you would need fewer
Yeah,
lawyers in this, but,
Then I was also
Okay.
trying to
I
make
get-
it
move
bit
us
more
over
Yeah,
to
the
the other.
younger
Okay.
people.
No, also make it a bit more broad.
yeah,
Looking at the other people around the table, what type,
yeah.
what do you think about acceptance of this type of role of a judge? Does it fit your image that you got in legal education? Can you place it somewhere?
Maybe it would leave too much room for debate,
Hmm?
both prior and after the settlement.
Yeah,
Does that make sense?
Most is not clear.
It would definitely take differently trained judges.
Yeah.
No.
Okay, so there would be a kind of vulnerability involved.
Yeah. Because it's still a bit arbitrary,
Yeah.
maybe,
Yeah.
since a judge is a human being.
Yeah, if you can hide, I'm only saying this because everything else fails. So yeah, I'm just trying to solve a problem which is unsolvable. That's different than when you say, okay, you brought in this problem, and after 2 weeks
Yeah.
I will solve it. Yeah.
What are you going to do with criminal cases, Moritz? Or are we talking civil and labor?
Yeah, problem-solving courts have been invented for criminal cases. So bring in the parents, family, etc., to deal with youth crime. Work with the victim on a solution.
The marathon bomber is not gonna get that treatment. I mean,
Who?
the marathon, the Boston bomber is not gonna get that treatment. I mean, you've got different kinds of crime. Youth crime, yeah. I mean, in
Let's
fact, Yeah.
let's
Okay.
try to see, because that's a big issue. The Boston Marathon bomber or the Microsoft case.
yeah.
Is problem solving just as feasible there? What would it look like?
Well,
Yeah, it's not gonna be. It
Well.
would be much. Yeah, I couldn't see the parties involved, especially in a big Microsoft case, willing to agree to something so brief and quick and
And kind of
it doesn't give them
arbitrary.
It
options
doesn't
to
say that it
go
should be
further.
brief or it could be different.
Yeah,
for
at
this
the other
case.
hand, they feel also, the bomber feel also needs acknowledgement of the problem, their country, their background.
I think this is a very cultural question. I mean,
Yeah.
as such, I don't think there is any reason why it shouldn't work. The only
No.
thing is that,
In
for
some
example,
countries
in
it
the
won't.
United States,
Yeah,
I
it
think
won't.
the
Yeah.
wish for revenge and
Yeah.
for retribution is very strong, and therefore it goes into a certain direction. But in Africa, I've seen amazing willingness to do problem solving for war criminals, and it wasn't an issue at all.
And then some not.
There's
Many of them were able to do that without any problem.
there's an interesting example in Holland on a big case involving
child abuse in Amsterdam. Terrible, 60 babies abused by
The most terrible thing
most
of
terrible
all.
that you can think of.
Yeah.
And it was completely within the framework of criminal procedure as it is, but the judges and many more of the people involved, the mayor and the people working with them and even the lawyers, they took a more problem-solving approach than you would probably have expected. And in a way, it worked because there was a lot of empathy with the parents, children, and what they went through. But at a certain stage, there was also space for trying to understand this guy.
Both,
Why
yeah.
did he do it?
Yeah.
Where did he come from? Etc. Etc.
Yeah.
So there was a kind of public truth. I wouldn't call it reconciliation, but there was some truth finding, and it was not completely adversarial. And this guy should be electrocuted type of reaction. So
Yeah.
just
Yeah, but you've got, what was it called, the child abuse case in, was it Belgium or France, I think? Utrecht? Yeah, was that, yeah. Yeah, yeah, but no, I think that's a different one, but the people got locked up for 2 years, and then it turned out, as that often happened in the United States, that the instructional judge went a little above and beyond, and it really hadn't happened. Child abuse is really difficult.
Can I just ask a question about this? Because the thing that I would see with the solving problems thing, the word that comes to mind is floodgates. So how do you solve it without being the one who solves it? So how do you do it in a way that you don't take away the self-problem solving capacity of the citizens? Because it will never stop. This is a, you know, there's always a problem that someone wants solved.
Okay,
So
yeah.
you need the capacity to empower others to solve their
Yeah.
own problems as
Yeah.
part of your problem solving. Otherwise
Yeah.
it has no limit.
Yeah,
Yeah, dus
And that's,
you don't need to take over the problem solving
No.
from the people,
No.
but
Yeah.
you need
so
to.
that would be a
this-
capacity you
yeah.
should have.
Yeah, I
Yeah,
agree.
yeah, as a friend of mine once said, I don't want, if I argue with my wife in the morning, that this has to go to the court to be resolved. People have got to learn to
No.
resolve some of their own problems.
as a
Yeah.
president of such a court, I would
Yeah.
try to cope with that through two mechanisms. I would use the pricing mechanism. Where's that?
Okay. It was in their funding, you said.
Yeah, funding. So you need pricing.
And how would you use that?
Just if you have the feeling that certain complaints come to me that shouldn't be there, I would raise the price of the issue until it covered costs. And if it covered costs, I wouldn't mind as a president then come in. Okay, if you want to quarrel with your husband before a judge and you pay for it, why not?
Well, why not just use private mediators? Why have to use judges?
The submission problem.
Submission
No,
problem.
that's the only
Yeah.
thing I can.
Yeah.
So-
My wife
Wow.
would never submit to a mediator.
No.
So I take a legal action against her in court, and then she has to
that
go
would
and she
work.
has to
That would probably
mediate?
work.
Dus it only works with a combination of last resort. Otherwise, there
Yeah,
is no
because
submission
otherwise,
problem.
yeah, but there's still a submission
Or
problem.
your remark
But-
is.
but, my second answer
No.
would be that I would really focus my procedures on stimulating settlements,
Yeah.
letting people grow towards a decision, and problem-solving courts do that. And they don't
Take it
they-
over the whole.
In a way,
no.
judges, when they are close to a problem, they feel that their intervention will not do it. That
No.
he has to make, or
Yeah.
she has to make the people work together to do it.
Yeah.
So
They
that
do
would
a
be
short
my answer,
intervention.
but I don't know
yeah.
whether it's a good answer.
Well, and I'm not sure where I've seen it. I mean, judges still judge. It's just that they encourage people to get services, and for example, the drug courts, it's not that you're mediating with anything. For one thing, it's a victimless crime, but you do insist that someone gets treatment, and if they do that, then the sentence will be lower. I mean,
Yeah.
there's no one to mediate with in drug
But then you
courts.
need some kind of system to say what is a silly case.
Yeah.
Yes.
Or no? how would that
Yeah,
work?
well, what is the silly
There
case?
should be a
I would
mechanism.
just use the pricing, yeah, and
Oh.
Yeah, that's what I'm saying.
I would leave it to people, what is this, yeah.
Well, I
No, no,
mean,
but
Can
what
we-
I'm saying
Yeah,
is,
yeah.
when do you,
Is
so
there-
you need some kind of
Yeah.
system, you need to train your judges in such a way that they know when they should invoke pricing and when they shouldn't.
Yeah.
Yeah, when I would have a court like that, I would go for a court funded by users. It's two
A
options.
whole court.
Yeah,
Yeah.
either it's important for the people, so then they can pay, or it's unimportant for the people, then I need the pricing mechanism to let them pay for my services.
Hey, but
Well,
if
we
you
have some
you
kind
know,
of reach-
Subsidies, I would help some people for free, of course.
Moritz,
Okay.
when it's a non,
There
when it's,
must be some cross
That's my question.
when it's a meritless case,
No, you just literally answered my question just now.
all right, then let me. When it's a meritless case, you're creating a terrible nuisance for the other party. Romania, the guy goes to the prosecutor and says, and this is true, my neighbor's trying to kill me by blowing barbecue smoke into my house. Now, you know, the neighbor then is gonna have to get a lawyer or do something if you accept that case. It's a ridiculous case, and there are lots of civil complaints like that. Courts have always been used by people to harass their enemies. It's, you know, this has been going on for centuries.
But that
You
happens.
file a case, and then the other person has to get a lawyer and come back and get a defense, and it
No,
just
you-
takes time,
You don't need a lawyer,
you know?
and the
You still
meritless
need
case
time.
will be thrown out much faster than in other systems. But let's go to
Number three.
the legal
Okay.
approach now.
How is that different from the first one?
Yeah,
That's what I
yeah,
don't
what's the difference
understand.
between last resort
Which was
and-
first?
Yeah.
No, but before then, because one thing, and you might have said that at the beginning, but one thing that seems to me important is that you're working basically with two variables. One is the institutional variables, judges or others, private or something. And the other one is the procedural variables, what kind of procedure are used. And you know, you could have judges working with different procedures depending on, you know, the ordinary procedure or special procedure that would be for small claims and the like. Or you could have private enforcers working with those procedures. Because a lot of the debate that you're having is about cost shifting, and you can shift costs
Yeah.
either through the institutional variable, to the procedural variables, or to use both. But I think in this debate, it would be useful that you identify for each of these issues whether you're working on the institutional, the procedural, or both.
Yeah. By institution, I mean the kind of judge or what?
Well,
Yeah.
let's have courts and private enforcers, and within that is, you put, and I know that that's overly simplistic, mediators, arbitrators,
Yeah,
private
okay.
ADR of any
Yeah.
sort, right? So you could have these two, but then within the procedural, you could have several procedural devices that would enable you to save costs, make access to justice broader and the
Yeah.
like.
Okay.
But these are two different variables you want to work on, and for each of those two, a lot of these issues that you're dealing with might have different answers depending on whether your starting point is courts versus private justice, or
Yeah.
ordinary procedure versus accelerated
Yeah.
procedure versus whatever. And so these are the 2x2 matrix that might be useful for
Yeah.
you to use, because depending on
So
where you
your-
stand in the
your-
box.
Your metrics would be,
Would be, you know, you can put out institutions and then divide, for the sake of simplicity, public and private. And then on the vertical axis, you would have procedures. And you could say, you know, again, to make it a 2x2, ordinary versus, you know,
Expedited
fast,
something.
accelerated, without. And then you can complexify that, but if you make this exercise by having each of these boxes, I think you'll end up having different answers.
How would you start to fill that in? Fill it in, because I'm not sure I get it yet. But you've got procedures, expedited, so for private, what would you do with procedures?
For the private,
Yeah, you got,
Well,
what would be
think
what would
about
be
the
an
difference
ordinary
between-
private, yeah,
think about the small claims through mediation versus arbitration.
okay.
So arbitration would be an ordinary, a long one.
Yeah,
Because you have to have certain kind of,
okay,
whereas a small claim among private, you could
Yeah.
have an accelerated one.
okay, we could have international, at one extreme, international arbitration, and at the other, small party.
Small
mediation.
local claims
Yeah,
between
Yeah.
neighbors or.
yeah, okay, okay.
No.
Yeah, because even in the States, we got the Judge Judy model, which is fast and public, and
That's right.
you get your day in court. You don't expect, you don't bring a lawyer, and the judge makes a decision on the spot.
Everything,
Yeah.
everything exists in these four.
Yeah,
four
yeah.
documents.
And probably the JPs in England are very much like the fast public. But they do have,
Yeah.
they try to provide services, insist on restitution, insist on treatment, etc. But it is fast.
It could be very useful.
Yeah, yeah.
But let's go
Yeah.
Okay,
back to it's a view we often hear. We are here, we hear from judges, we are here to solve
Yeah.
legal issues. And if people have other issues, psychological
Oh.
issues or whatever, they should go elsewhere.
Yeah.
but isn't that sort of the last resort model? Because the last resort model depends on it's just the law.
No, you can be very active and close to people or and fast.
Unfortunately.
But saying, okay, I only take up the legal issue.
Yeah,
Yes.
okay.
Yeah.
So
This
it's
is very.
But how would you differ it from the last, I still don't understand quite, the last resort, as I've heard it explained, is always if mediation, administration, everything else fails, then you come to court and it's gonna be a legal answer. And that's the last resort.
Is this more
Yeah.
of like an ordering of it,
Yeah,
where you
but
go to the
it's-
court
Yeah.
first?
You don't wait forever. UK courts wait
Okay.
forever. I heard the stories again about how they deal with childcare cases. They ask the lawyers to come and they ask the government agency to come and they sit around the table and then they say, okay, I've listened to you and I think that this should be considered and this should be considered and I will see you in 2 months and we'll see how far we get because I can't decide it, it's too complex.
Well,
And then
isn't
they-
that problem, oh, I see,
Yeah,
but
and
you're not
then
asking,
they,
you're not
all the
mediating.
time, they keep postponing, they see themselves as the referees, not as a problem solver, but the referees of the debate between the parties, and it takes endless.
Actually, I don't think most UK civil cases, which are a minority, get solved that way. The stuff where you get a lot of back and forth is in the JP court. I know, I agree they're long, and they're long because there's
Yeah, but-
discovery and all
Well,
kinds of things.
But let's focus on
Yeah.
this one.
Yeah.
Well, this is very.
So
very- very-
the courts are there
Yeah.
to answer legal questions,
Yeah.
they do it quickly, they hear the witnesses, they hear the experts, but they do it effectively and quickly. I think some German courts are like that, they're very legal in their thinking and but they're also fast.
Well, they're fast because they got 23 judges per 100,000 population,
I-
as opposed to.
Whatever it is,
They got a
Maurits,
lot
I
of
think,
judges.
exists.
I think
Yeah. What are the
the
implications?
Dutch
Yeah.
quality kei
Yeah.
reform, what we are working on it.
Yeah,
My colleagues
Thinking
approach
this
is,
way.
is thinking this way.
Yeah.
And what are the implications? If you want to be
They
a
want
court
to do
like
it
that,
fast, but only from the legal perspective.
Yeah.
yeah, okay.
So
They
so
say
what
we do also problem solving, but that's not natural.
So it's a zero-sum game, you win.
They say I think the
I
combination is they think that it is now a last resort that takes a lot of time,
Yeah.
and now we are gonna do an innovation, and now we're gonna we do
Okay.
free.
So
Yeah.
you simplify procedures, and
Yeah.
you don't, and you
Exactly.
discipline the lawyers.
Yes, and
so
we do
that
have a lot of timetables.
Yeah, okay.
Time set. What is timetables?
Yeah,
Nee,
yeah.
That's
yeah.
great.
Yeah.
Yeah. And then it will be going faster, and then it will be better.
Yeah, but I'm sorry, aren't we doing I'm not sure how good we're doing this.
I'm not sure
I
either.
mean, last resort, we were designing a good, well-functioning last resort
Yeah.
thing.
Yeah,
But we're mixing it up with bad things. I mean,
Yeah.
we're also
Yeah,
mixing it up with saying
exactly.
very late, not
Yeah.
for people,
Yeah.
legitimacy issue.
Yeah.
Well, a good last resort has a result, does make sure that it is legitimate
Yeah.
and it
Yeah.
is there for people, it just works in a different way.
Yeah.
Solving problems.
I added the
But
negative
this
things,
is
but that was the
issues
balance.
that you have to take care of.
Yeah.
So,
Yeah.
so how do you do it?
Okay.
Because it will, if you say, I will only be there if everything else fails, you say
well,
no to a lot of people first. So that will cost you legitimacy. It will.
But you don't say no,
People
you
have
send
to-
them
you say
somewhere
no,
else.
Yeah, doesn't
Yeah.
have to.
maybe
That's
when,
saying- That's
yeah.
saying no.
And it's not necessarily slow then.
But then
No.
there,
Yeah.
are we designing are we talking about what
A-
would
a
a good
Yeah.
answering law
Sure,
and applying
sure.
facts
Yeah.
thing
Yeah.
Okay.
look like? Okay.
Yeah.
Yeah,
That's
that's what we do.
So then I think you need to be embedded in a system that has quick and easy access to all the other issues.
Mhm.
So if you say, I only look at the legal issues,
Yeah.
and you have somebody
Yeah.
before you
Exactly.
with a psychological problem, you
Yeah.
have an immediate referral system to a psychologist
That's
or
what you do in the
something
last
else.
resort.
yeah,
So if
Yeah.
it is
Yeah.
to
well,
work,
that's
you
maybe
need
when,
to have that link immediately. And you need to be able to see
I need both, yeah.
when something is not legal, and then
Yeah.
you need to be able to
Yeah.
point somebody in that direction.
Yeah, and the only problem is that if you have only legal-minded judges, they can't herkennen,
Recognize the
they can't acknowledge that there should be
Yeah,
a triage to the
Yeah.
Yeah.
other one.
so you need non-legal judges
Yeah.
as well. Yeah,
Yeah, or you're non-legal. Yeah, you need them, but if you have the good last resort judges,
Yeah.
they will do both. They can be they can do the good
Good
diagnosis
yeah, yeah,
and
yeah.
refer when it is needed, or
Yeah.
do the
That's
solving
why I
problem
think
when it
this-
is needed,
Yeah.
or
That's why I think the 1 and 3 can be
But
combined.
that's,
Yeah.
yeah.
we are all system thinkers,
Yeah.
and
Yeah.
we hate systems not working.
Yeah,
Yeah.
So I will stand here, this doesn't exist.
no.
But
No, that's
we-
good,
we
and
have
I don't know.
this. Yeah.
So what do we have in a situation over here where it gets to the courts and he finds that there are several non-legal issues and several legal issues?
Yeah.
Do we have a situation where he's able to address all of those, or are we gonna have to split the parties off and have them go through two separate processes?
Well, I won the last one, but that's
That seems like make it overly complex for the parties.
yeah.
Yeah, that's.
And
that's
expensive,
the
maybe
implication.
expensive,
So
that's what we say.
complexity can
Yeah.
be, and you have,
You have to good, yeah.
there's complexity of dealing
Yeah.
with all these interfaces. You see it in cases where expertise is needed, medical expertise
Yeah.
or expertise in calculation of
Yeah.
damages. You see
Mhm.
these interfaces have a lot of
Yeah.
problems.
And-
What I think good and maybe is an example in Holland, the way the family judges has grown. I think we have family judges who in family
Yeah.
disputes we have also a lot of what I said before outside mediation, good working.
Yeah.
So that need a very small intervention of the judges. And if there is complex conflicts at the family judges now, they say, well, we want to refer to
Yeah.
psychologist. Psychologist.
So you have to, they refer to others and the
Yeah.
case comes back,
Yeah.
etc.
And they are last
Yeah.
and they are last resort. So maybe the family dispute resolution system in Holland will be an example of how it can work. But
Thank you.
het is voor mij.
It says me on
Yeah.
it. That's good for
Will,
you.
will it be more legalistic, this procedure? Will it be more, if you only address the legal questions,
Yeah, people who
will it be more formal?
But yeah, if they're only solving legal issues, yes, I would think so.
Mm.
because that would be entirely about the formalities of law,
Yeah,
formality of the laws,
there will
rather
be
than
a
just solving the
certain
problem.
tendency to formalize issues, to say, okay,
Yeah.
you're not allowed to complain anymore because you haven't been in time. You will
Yeah.
be, because that's the way they can.
Yeah. It's
Well,
very
yeah, that's
clear
how you
if you
set the
leave
time
the
limits,
court,
yeah.
it's very
Huh?
clear what has
That's-
happened, yeah.
That's how you set the time limits. People they have a certain amount of time to submit their evidence or to submit their papers or
Yeah.
to answer, and if they don't, that's the only way you control the lawyers.
Yeah.
So it may be lawyers' paradise, but lawyers are going to be disciplined.
Yeah, discipline lawyers.
Yeah.
Anything, any other, how will it be,
You need something good on facts. You need to know what
Yeah.
the facts are.
Yeah.
Something, if you want this to work really well, you need some kind of very clever system.
Yeah, and you need to know,
What are the facts?
you have to need big dossiers.
Files.
Yeah, or,
Yeah,
yeah.
you need every fact and every dossier, every thing in
Clear.
your paper. That's
It
what,
sounds
that's what we write down now in the new reform.
No, but-
the whole complete dossier has to be there.
Right.
But some people don't use dossiers.
Huh?
Some people don't use dossiers. That's very continental.
Yeah.
But the other
No,
thing is, the other thing is, if you're going to make it fast, you actually have to limit the witnesses and the
Yeah.
evidence. The judge has to control the
more regie, yeah,
Yeah.
more
the inputs from the parties, because otherwise they'll just go on forever.
yeah, more active role.
But how would he, how would he balance that with fairness before he's actually seen the evidence?
Yeah, yeah.
Yeah.
You see, this is interesting.
Yeah.
You see this happening in courts, huh?
Yeah.
The
Yeah.
new rules to say,
Yeah.
okay, you can have only so many words to make your
Yeah, this
statements.
is now what we
limiting-
want to.
Yeah.
In the US, they limit
legitimate.
the number of pages and the margins.
Yeah.
Yeah,
And the font.
Yeah,
yeah,
Yeah.
yeah.
and that we call regie.
Yeah.
What's regie?
But do they limit the actual number of pieces of evidence you can submit?
Well,
Yeah.
the judge can actually decide, I mean, you know that, the judge can decide
Yeah.
whether evidence is required or not.
Right, but I mean, he would still have to see it. That doesn't seem like
Yeah,
it would
well, they
save
would
us
say
any
we wanna
time.
bring witnesses from so on and so forth,
Okay.
but in most common law countries, and I think in civil law too, the judge, and the Germans certainly, exercise some control over what the parties can propose, because that's a common delay
Yeah.
producing tactic.
Sure.
Will it be more adversarial than the others?
Not necessarily, I don't think.
Well, I guess.
I mean, there's no reason it has to be.
It is 1 and 1 is
Germans are not adversarial.
it's not 1 and 1 is 3.
Yeah.
Sorry?
Yeah, I don't. It is 1 and 1, and then I
Yeah.
decide it's 1.
Yeah, yeah,
And
so
it's not 1 and 1
more-
is 3.
It's more polarized, I
Yeah.
would say.
I see.
Yeah, but I don't, for example, if that's the German system isn't terribly adversarial.
It's black and white.
I think
or,
what you're saying is that the
Win or lose?
the
Yeah.
decision will be zero sum.
Yeah.
Right.
Because someone wins and someone loses.
Yeah, it's the way we lose.
Yeah.
Yeah, I guess. Yeah.
You can apply the law based on the principle
Yeah.
of proportionality as contained.
Well, okay, yeah, you could do that.
But
Yeah,
this
it can
law
be
has
some-
an answer.
Yeah.
There's a lot of that.
So if you
But
want
is
to
the law
avoid
clear?
this, you
Does
need
the law has an answer to the problem?
Yeah, very
intermediate
often it doesn't.
decisions.
Yeah.
So it
Yeah.
has, but there's,
Yeah.
the law is full of proportionality
Yeah.
kind of
Yeah.
things, which you then apply and you come up with
Yeah.
some kind of
Yeah.
thing in the middle.
Yeah, but it's not
It's
like.
clear.
It's not like a mediated decision, though.
No,
I mean, yeah, it's clear that
Yeah.
if I get the
Well.
divorce, I don't cut the baby in half, or you get everything and I
Yeah.
get nothing. But,
As a court president, can I be, is it easy to fund this stuff?
Nou, doe ik ze in Holland, ja.
well, my question is, how expensive will it be for the client?
Well, you need lawyers.
You need lawyers, yeah.
Without lawyers, you can't do this procedure.
Yeah,
So it's more
Of course, you
expensive
don't
for the-
understand what's happening in the court.
yeah. But judges who I think will be more activist in this one in terms of controlling the rhythm of the process could hold down costs by delays, by reducing delays.
So you need legal aid? It's
Yeah.
because it's
I s-
more
I-
expensive
yeah,
for
I guess.
clients,
Ah,
Yeah, yeah. Or legal insurance.
ah,
whatever.
Ah.
Yeah.
yeah.
Legitimacy?
Yeah. People may not be happy with the results, but I suppose it's legitimate.
Well, yeah, that depends
Mm.
on what kind of people. There are people who are glad when there is a certainty, and there are
Yeah,
people who
yeah.
are glad when the problem is solved.
Yeah.
That's
Well, just for the legal issues that remain within the court, then would it really be any different than legitimacy currently? Because it sounds like it's going to be a fairly, once you get to the legal issues and it gets to this court, it's going to be fairly traditional from
Yeah.
there on out, correct?
Yeah. Yeah.
So it would just be all the same
I
legitimacy.
mean, when I was in Utrecht at 14 March at the escalating on the procedure, there I was sitting with someone who was very glad with an example that there's a judge who made the decision. He has lost, but he was very
was
glad.
okay, yeah.
It was okay.
Let's bring it to an end with 2 questions to all of you. And maybe you can answer them before we share it for yourself. If you would have a column with implications for you, you got stuck somewhere in your life, in some relationship, which court would you prefer to go to? And the second question is, which court would you see as would you think that would be best for society in general? Who would be want to be in one? In 2?
For me.
1, 2, 3, 4, 5, 6.
Yeah, I can't answer this way.
Okay. Who would like to be in that one?
Am I all alone?
And for society, what would be the best option? After this we discuss. But
Yeah.
what, for society, 1 would be the best.
A good working one.
Yeah,
A positive
two.
one, yeah, I think.
Who would be problem solving, thinking that's the best one for society?
What happened to the other 5 people?
Ja, niet gestemd, hè?
Who would,
Nee.
would think the third option would be best for society?
I don't know.
3.
Mag je liever een mix?
En als je nou Sam vraagt voor internationale conflicten?
We're
You don't
assuming
know?
a last resort option in number
No.
2, correct?
Nee?
Misschien
Ja?
een beetje, maar
De ICC?
ja, dat is duidelijk één.
Ja, maar dat is voor de maatschappij, voor de internationale maatschappij toch het belangrijkste, of niet?
Ja, maar het is, I think the issue, yeah, I mean, I don't want to personalize it, but the,
Okay, most people present here want to be in that court, and most people think that that court would be bad for society. That's an interesting idea. So let's.
Are we assuming a last resort option in the solving problems?
Huh?
Are we assuming that there's a last result option in the solving problems if everything comes to a head and there can't be
We
agreement?
looked at it separately, I think.
Are we assuming? Sorry.
Yeah,
Well,
I like a combination, that's why
Sorry,
I.
I was working on Matt's question.
Well, there has to be surely there has to be some kind of mechanism where if the parties just can never agree,
Yeah.
that it has to stop and it goes to a court of last resort.
Yeah, but it says so, no?
Correct.
One of the items.
Yeah, but
Yeah, so we're assuming that,
the
right?
problem-solving
Yeah.
court is taking decisions. It's not only leaving it to the parties.
Yeah.
It's taking decisions.
I think maybe the reason why I have a difference between my personal question and sorry, that I think there are a lot of people who can't solve their problems.
But
I
the
have
judge
not
can
around.
the judge can solve it for them. They
Yeah, but if you have you are not able to reflect on yourself or to have a problem-solving
Okay,
mind.
so other people need a court of last resort.
It depends the people, but I think the society has a lot of people who are not able, who are so, maybe
But the
psychologists.
problem-solving court in the US deals with drug crime and people who can have very serious mental problems
Yeah.
and takes decisions for them. So that's not, problem-solving court is not saying you should solve your own problem.
So you have an example of good, effective
Oh.
working problem-solving courts.
Yeah.
Well, the,
Yeah.
the drug courts in the
I
US
don't know
are,
them, but
I don't know them
yeah. If
Well,
you
the-
know
From
them.
the US.
the drug courts in the US are more about, it's just really just a part of the sentencing.
Yeah.
They get sentenced, and then part of the sentence is if you complete the program
Yeah.
issued by the drug court, then your sentence will be lifted.
Yeah.
So it's not really solving anybody's problem there. It's just giving them an option to no longer have a conviction on their record.
I don't know, they call them problem-solving courts. And,
Yeah,
Well,
and,
because the idea is
and-
that,
and one
It's
thing,
more about solving society's problems
Yeah.
that there's drug addiction than
Yeah.
solving any individual specific problem.
and one important thing is that's
it's
why
not what I read in the evaluations.
we were thinking about a good working last resort court, and that's a good one, has the solving problem in it
Yeah.
also. Because it is a multi-door courthouse, that's the reason why.
But that's not what people, people talk about a court of last resort, judges think about themselves as a referee, and we will only do something if it's absolutely needed that we take a decision. That's court of last resort. That's
where
their
does that,
attitude.
where does that operate?
In the UK, as in many US procedures, when there's big time lawyer procedures, in commercial arbitration, you see it a lot. It's
Well, they're encouraging
having
people to
it's
settle
family,
first.
family,
Yeah. They're
Oh,
encouraging
that's
people
the
to
difference that
mediate.
we
Yeah.
can't see it in itself. We make a combination, and
It's,
yeah,
of
that's-
course, it's an abstraction, but
Yeah.
it's different.
Yeah.
Type of
Well, when I had a job discrimination pursuit, I would go for 3. And those are about the only times I ever considered going to court. I don't think I like problem solving.
if you're pregnant and you are
Yeah.
dismissed,
Yeah,
then you
yeah, I'd go to that one. I wouldn't,
No.
there's nothing to mediate there. They discriminated and that's it. But I can think of other problems where problem solving might be all right.
Okay.
I think, I don't wanna vote because I think you need them all. Although I think this court of last resort that you set up is really a straw man. I think it's really more, it's an ineffectual 3.
Yeah, might be. It's,
yeah.
yeah,
At the
but
other
it's-
hand,
it's-
if
it's- It's things that judges tell us, so it's not my invention.
Well, but when I hear
Are we,
judges talking about last resort, what they're saying is people ought to find other ways to resolve their problems. And we will, if they can't find them, then they come to us. That's what they mean by last resort. It isn't necessarily slow, although I agree with he. There are incredible delays in US federal courts and in the formal courts as opposed to the JP courts in the UK. But that's, I don't think it's part of the package. That's just part of how things have worked out. It's not intentionally slow. Yeah.
But I have also a
I'm not so
question.
sure. I've heard
yeah.
judges say it's no problem that we are late because then people have more time to solve their own problems. There are really a big group of judges who really think that.
But
in this
case, no,
Rationalization,
yeah.
but,
There are others that set a firm trial date and will have the trial then because they say once the firm trial date is set, they get, say this, sweaty palms and they settle. And
that's,
Yeah, but that's the last resort. The idea is we encourage them to settle, and we encourage them to settle quickly. And if they can't, then they come to us. That's what's meant by last resort.
What do you have learned this
let's
2 hours?
let's
Yeah.
bring it to the
Hours.
conclusion.
Yeah.
I think we have a lot more, of course, these 3 are abstractions. It's an abstract choice.
Yeah.
I think we have collected many additional implications, and that was what we were after. And we have also learned that
Yeah.
it's very hard to distinguish 3 different types
Yeah.
of courts if you're very close to courts in your
No,
mind.
it's an optimal interaction.
But
yeah.
I have the feeling that it's still 3 different types, and I haven't heard a clear fourth version, or I haven't seen any of the two categories merge, but we can take a look at it.
Not the
Well, I can
fourth.
see that answering the question of law and applying law and facts is something you could do in last resort, and you could do it in solving
Yeah.
problems to a degree. So it
Yeah,
could,
the missing things
it
you have
could
to
be
add.
a
Yeah.
scale that you could use in both.
Mhm.
I think that the last resort in solving problems are too clear.
It seems like the best option would be a combination of a pretty fairly equal combination of the three.
Yeah.
The?
Where we're a fairly equal combination of the three, where
Yeah.
you go into solving problems and for the legal issues that they can't solve, it would
Yeah,
spread
but I think
over.
what I find interesting is that if all the judges I've talked to, I clearly know some judges that are problem solvers. And that's
Yeah.
how they see themselves, that's
Yeah.
how they experience their role, that's what they want to be.
Mhm.
Yeah,
And there are others who say, my role is that.
yeah.
And that's interesting to see,
Okay.
that you've got people who have a self-definition
Yeah.
of what they are about,
Mhm.
which is very different.
Yeah.
Maybe this is also part of the problem, that the judges are trying to pigeonhole themselves or define themselves in a way that
Yeah.
isn't necessarily a best mechanism.
But clearly that has happened, that you have these two different ways of perceiving their own role, and that's then what they start doing.
So maybe the best option would be
I
just
think
to,
that's the basis of these three categories. It's how the judges talk about themselves.
Yeah.
How they talk about themselves as problem solvers, and these judges don't care a lot about whether it's legally sound, or they find a way to fit it in the legal
Yeah.
system. They're
Yeah.
very creative in
Yeah.
that. There's also judges who say, I don't want to solve people's problems. I don't want to be a psychologist. I don't want to hear about these things. I want to hear what issue the lawyer wants me to decide, and I can decide on that. And I can do it quickly, and I will twist the lawyer until he makes his point very clear
Oh.
and focuses on all his question on the legal issues and nothing else. And there's also really judges who wait and see what happens, and the mess cannot be big enough for them,
Yeah.
and it starts interesting for them if they get a file at the end of the procedure, and then they want to write a decision, and then they will sort out all the mess.
Yeah.
And that's typically the.
Maybe we should call them strategies.
And if you ask if the society needs
It's
that.
not so much
Yeah.
it's not so much different courts, but different
Personal
Yeah.
strengths.
Perceptions,
Yeah.
that's
Yeah.
how we call them in the law.
And if you ask to me if that last resort judge, is that what the society needs, then I say no, that's not what he needs. Then my vote will
Yeah,
dismiss.
maybe we got a bit
That's-
confused.
yeah.
Okay, that's a good point.